Hi everyone, you're watching The Caffeinated Corporate Lawyer, where we try to make meaningful content to help you better understand the intricacies of corporate law. I hope you guys are absolutely caffeinated because today we are going through some more important definitions given under Section 2 of the Companies Act 2013 in continuation from the last video. If you guys recall, we had discussed the definitions of company, body corporate, previous company law, foreign company, memorandum and articles given under Section 2 in the previous video, which means we have covered a total of 6 clauses so far out of the 95 clauses given in Section 2. Today we are going to look at the definitions of private company, securities, public company, holding company, subsidiary company and associate company. You can find the timeline below to directly jump to the relevant definition or relevant portion of the video that you want to watch. So without further ado, let's dive in. First up is the definition of private company, which is covered under Section 2 Clause 68 of the Companies Act 2013. Now, this is a very important concept and you will be asked questions on it time and again during your internship interviews or job interviews for sure. For instance, what is a private company? What is a public company? And what are the differences between a private company and a public company? So as a law student, you need to understand these definitions very well. So Section 2 Clause 68 defines a private company. It states, private company means a company having a minimum paid up share capital as may be prescribed and which by its articles 1. Restricts the right to transfer its shares. 2. Except in case of one-person company, limits the number of its members to 200. Provided that where 2 or more persons hold 1 or more shares in a company jointly, they shall, for the purposes of this clause, be treated as a single member. Provided further that persons who are in the employment of the company and persons who, having been formerly in the employment of the company, were members of the company while in that employment and have continued to be members after the employment ceased, shall not be included in the number of members. And third point, prohibits any invitation to the public to subscribe for any securities of the company. Now, let's break this definition into different parts and understand it. The first part of the definition says private company means a company having a minimum paid up share capital as may be prescribed. What it means to say is that a private company should have the minimum paid up share capital, which should be in accordance to the minimum paid up share capital as is prescribed by the central government. If you click on the footnote, it says omitted in clause 68, which says of 1 lakh rupees or such higher paid up share capital has been omitted. So basically, before this amendment came into force in 2015, all private companies which were being incorporated had to have a minimum paid up share capital of rupees 1 lakh or higher, which was prescribed by the central government. However, post the amendment, the requirement of having a minimum paid up share capital of 1 lakh rupees for the formation of a private company was done away with. Now, at the moment, no amount has been prescribed, which effectively means that the monetary limit imposed earlier on the formation of the private company has been deleted. This was done to improve the ease of doing business in India. So now, private companies can even be formed by having a paid up share capital of 50,000 rupees. Hence, there is no minimum paid up share capital that is required for the formation of the company. If we read further, we can see that Section 2 Clause 68 says that Articles of Association should impose 3 restrictions on a private company, which forms the basis of its definition and is as follows. First restriction is on transferability of shares. The Articles of Association of a private company impose a restriction on the transferability of shares. However, this does not mean that there is a prohibition on the transfer of shares of the private company, but only a restriction on transfer of shares, which should be subject to the Articles of Association of the company. A private company can still transfer its shares, subject to the procedure which has been laid down in the Articles of Association of the said private company. For example, there may be an article which might say that the member of the company can transfer his shares to another person, subject to the approval of the board of directors of the said private company. The rationale behind this restriction on free transfer of shares is to prevent any person or every person from acquiring and holding the shares of the private limited company and thereby defeating the very objective as to why it was created in the first place. It is important to understand that a private company enjoys certain privileges and exemptions and is able to avoid intense scrutiny from regulatory authorities because it constitutes of a limited number of members and does not involve the public money. As a result, private companies are not required to be as transparent and accountable as public companies are, in which the shares are freely traded on recognized stock exchange. The second restriction is on the number of members. Section 2 clause 68 imposes a restriction on the number of members a private company can have, which is limited to 200. This means that a private company cannot have more than 200 members. However, when we calculate the total number of members of the company, we are to exclude two categories of people as per the second proviso to section 2 clause 68. First exclusion is the persons who are in the employment of the company. For example, if you are employed by the private company and hold shares in that company, then you would be excluded from this limit of 200. And second inclusion involves persons who were former employees of the company and at the time of their employment were also members of the company and have continued to remain as members of the company even after their employment ceased. They will also not be counted towards the limit of 200. For instance, you had purchased the shares of the company when you were working as an employee and have left the job now, but still hold the shares in the said private company. Then you won't be counted towards the limit calculation of 200 members. Coming to the first proviso, it means to say that if suppose Mr. and Mrs. Mehra hold one or more shares jointly in a company, then they would be treated as a single member and not as two distinct members of the company, as they jointly hold the title to the shares. This is again useful to calculate the number of members of a company. Again, we can see that less public money is involved as the definition restricts the total number of members of a private company to a mere 200, excluding the current employees and former employees who are members of the company. In comparison, there is no restriction on the number of members that a public company can have. For your better understanding of how the limit of 200 is calculated, let's see a math problem. Assume that XYZ Private Company Limited has 300 members, and out of these 300 members, 60 are employees of the company, 20 shares are jointly held by 40 members of the company, assuming per share is held by 2 members. 30 members were previous employees of the said private limited company. 50 members had subscribed to the shares of the company after they left the job. If we apply the above definition, then current total members as per definition of clause 68 of the company stands at 190, which is within the limits as set by the definition. Are you getting the same number as we are? Hit us up in the comment section. Now, the third restriction says restriction on invitation to the public to subscribe to the securities of the company. This means that a private company cannot offer its securities to the public by way of prospectus or in any other manner which can be construed as a public offer under the Companies Act 2013. This means that the private company can raise capital by only a private approach, that is, by sending offer letter to a specific number of people who have been identified by the company. Any offer to subscribe to the shares, debentures, etc. to the public or by way of an advertisement to raise investment from the public would be construed as a public offer, and the private company along with its officers who are in default would be liable for fine and imprisonment. Now, what do you mean by the term securities? So the meaning of securities is covered under section 2 clause 81 of the Companies Act 2013. Securities means the securities as defined in clause H of section 2 of the Securities Contracts Regulation Act 1956. So basically it is redirecting us to another act where it is defined. So if we see, it says section 2 clause H of the Securities Contract Regulation Act says that securities include 1. Shares, scrips, stocks, bonds, debentures, debenture stock or other marketable securities of a like nature in or of any incorporated company or other body corporate. And we can see that there's a list of items which are also included in the definition of securities, which is given over here. But at the moment, you only need to remember that it includes shares, debentures, stocks, bonds, or any other marketable securities of a like nature. Again, we can see that this definition is not exhaustive, but is rather inclusive in nature. So back to the definition of private company, by imposing these 3 restrictions on transferability of shares, on number of members and on public offer of its securities, the idea is to ensure that public money isn't involved and therefore private company is not liable for as many disclosures and filings which otherwise have to be made by a public company. To sum it up, a private company does not have to go through the same scrutiny and surveillance as a public company is required to go through by virtue of its definition under clause 68. So now, let's see the definition of public company, which is given under section 2, clause 71 of the Companies Act 2013. It says public company means a company A which is not a private company and B has a minimum paid up share capital as may be prescribed. Provided that a company which is a subsidiary of a company not being a private company shall be deemed to be public company for the purposes of this act, even where such subsidiary company continues to be a private company in its articles. So, the definition says any company which is not a private company would be a public company. Secondly, it should have the minimum paid up share capital as may be prescribed from time to time by the central government. Again, like in the case of the definition of the private company, no such prescribed paid up share capital has been provided for the formation of the public company. However, if we click on the footnote, we can see that before the amendment came into force, it was a prerequisite for every public company to have a minimum paid up share capital of rupees 5 lakhs or higher. This limit has been deleted by the Companies Act 2015 amendment and is not there anymore. The proviso to clause 71 further states that any company which is a subsidiary of a company that is not a private company would be deemed to be a public company for the purposes of this act, even when the Articles of Association of such subsidiary company says otherwise. So let's see this with the example. Let's assume you have a company called ABC Public Limited Company and it holds more than 50% of the voting rights by virtue of its shareholding in the share capital of PQR Private Limited. Now, PQR Private Limited was incorporated as a private limited company and its Articles of Association is in compliance with all the conditions that have to be met to be a private company. However, PQR Private Limited would be deemed to be a public company as per the proviso to clause 71 because it is a subsidiary company of ABC Public Limited, which is a public company. Now, I have a question for you guys. Would the subsidiary private company, which is deemed to be a public company as per the Companies Act 2013, be required to amend its Articles of Association to convert into a public company in such a scenario? Hit us up in the comment section and let us know what you think. Now, moving on to the definition of holding company, which is covered under Section 2, Clause 46 of the Companies Act 2013. It says, holding company in relation to one or more companies means a company of which such companies are subsidiary companies. Explanation to this clause, added by the Companies Amendment Act 2017, states that for the purposes of this clause, the expression company shall include any body corporate. First of all, the meaning of holding company cannot be read alone without using the term subsidiary company, as holding and subsidiary companies are relative terms. In layman's language, you can say that these are complementary terms. What it essentially means is that the company which has a controlling influence over the other company would be called the holding company, and the company that is being controlled by the holding company would be called the subsidiary company, as depicted in flowchart 1. It's important to understand the explanation to this clause, which says that for this clause and for this clause alone, the term company would include any body corporate. So, if you guys see flowchart 2, where ABC is a limited liability partnership which falls under the bracket of body corporate as per the definition given under Companies Act 2013. Now, ABC has control over PQR, which is a private limited company, by virtue of exercising more than 50% of the voting rights in the company. As a result, ABC is the holding company and PQR is the subsidiary company in this setup. This is possible only because for the purposes of this clause, we are treating the term company to include body corporate as well. That's why we are also labeling ABC, which is a limited liability partnership, as the holding company. Now let us try to get a better sense of what is meant by the term control. For that, we'll have to look at the definition of subsidiary company, which is given under Section 2, Clause 87 of the Companies Act 2013. Subsidiary company or subsidiary in relation to any other company, that is to say the holding company, means a company in which the holding company controls the composition of the board of directors or exercises or controls more than one half of the total voting power, either at its own or together with one or more of its subsidiary companies, provided that such class or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such numbers as may be prescribed. Explanation for the purposes of this clause says, a company shall be deemed to be a subsidiary company of the holding company even if the control referred to in subclause 1 or subclause 2 is of another subsidiary company of the holding company. Furthermore, the explanation says that the composition of a company's board of directors shall be deemed to be controlled by another company if that other company, by exercise of some power exercisable by it at its discretion, can appoint or remove all or a majority of the directors. Furthermore, the expression company includes any body corporate. And finally, layer in relation to a holding company means its subsidiary or subsidiaries. So if we look at the first part of the definition, it clearly says that subsidiary company in relation to any other company, which means that subsidiary company is again a relative term and cannot be read alone without the term holding company. The ways in which a holding company can have control over another company is covered in the next 2 points. Let's understand this with the help of flowchart 3. So let's say ABC Private Limited Company is acting as a holding company of XYZ Private Limited. Then ABC would be deemed to be a holding company of XYZ only if it exercises control over XYZ in any of the following ways. So, first possible scenario can be that ABC controls the composition of the board of directors of XYZ, which is the subsidiary company. What this essentially means is that ABC should have the power to appoint or to remove majority of the directors in the board of directors of the subsidiary company, that is XYZ, or where ABC is said to have power where a person cannot be appointed as a director without the support of ABC Private Limited Company in XYZ. This is what the first point says. Now, there can be a second scenario in which ABC Private Limited has more than 50% of the voting rights or voting power in XYZ by virtue of holding majority shares in the XYZ company. This will inadvertently mean that ABC is the holding company of XYZ. For example, suppose the total paid up share capital of XYZ Private Limited is 1000 shares with one voting right each. Then ABC Private Limited would be the holding company if it holds more than 500 shares in XYZ, since that would give ABC more than half of the total voting power in XYZ. This is second way in which ABC can acquire control over XYZ and would be thus called as the holding company. This is depicted in point 2. Now, what if ABC is a private limited company which is incorporated in United Kingdom instead of being a private limited company incorporated in India? Would it still be a holding company as per this definition? The answer is yes, because as we saw in the explanation to clause 46 of the holding company, that company includes the term body corporate for the purposes of clause 46. Similarly, you will see that the explanation to clause 87 also includes that the term company includes body corporate for the purposes of this clause. Now, let's understand the proviso to section 87. It says that provided that such class or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such numbers as may be prescribed. So first of all, if we read point D of explanation, we can see that layer means subsidiary or subsidiaries. So what this essentially means is that if A is the holding company and has B as its subsidiary company, and B company is further acting as a holding company to another C company, then this means that A has two subsidiaries under it, or in other words, has two layers of subsidiaries. Why? Because C would be the deemed subsidiary of A company. Refer to point 1 of explanation, which says A company shall be deemed to be a subsidiary company of the holding company even if the control referred to in subclause 1 or subclause 2 is of another subsidiary company of the holding company. This essentially means that where the holding company's subsidiary has its own subsidiary, then it also becomes the subsidiary of the first mentioned holding company. Let's understand this with the help of flowchart 5. Over here, A is the holding company which has B as its subsidiary company, and B has its own subsidiary company in the form of C. In this setup, C would also become the subsidiary company of A. Another important point to note is that over here, B is the first layer of subsidiary and C is the second layer of subsidiary company. As of now, as per the company's restriction on number of layers rules 2017, no company other than a company belonging to a specified class can have more than 2 layers of subsidiary companies. Therefore, if in the above mentioned example we add another subsidiary B company whose holding company is C company, then this layer would be in violation of the company law. This is because A would also become the holding company to D company, and this would become the third layer or third subsidiary, which is not allowed as per the company's restriction on number of layers rules 2017. Here's something to ponder. Can a subsidiary company become a member of its holding company? Hint: refer to section 19 of the Companies Act 2013 and hit us up in the comment section. We will discuss this aspect when we read section 19 of the Companies Act 2013. Now, let's see the definition of associate company, which is given under section 2, clause 6, and is as follows. It says, associate company in relation to another company means a company in which that other company has a significant influence, but which is not a subsidiary company of the company having such influence and includes a joint venture company. Explanation for the purpose of this clause says the expression significant influence means control of at least 20% of the total voting power or control of or participation in business decisions under an agreement. Furthermore, explanation B says the expression joint venture means a joint arrangement whereby the parties that have joint control of the arrangement have rights to the net assets of the arrangement. So, first point to note is that the associate company concept is also in relation to another company. As per the definition, if A company has significant influence over B company, but where B company is not a subsidiary of the A company having such influence, then B company would be called as the associate company of the A company. So, what do we mean by the term significant influence? The explanation to the clause provides that significant influence means that A company should have at least more than 20% of the voting rights in B company, or should have some control over the making of the business decisions under the agreement. Additionally, the definition of associate company would also include joint venture company, which is defined under point B of the explanation to this clause. Now, let's take a moment to analyze the concept of subsidiary companies and associate companies simultaneously, based on the percentage of voting rights held by the company with the help of this flowchart too. As you can see, if the A company holds more than 20% of the voting rights but less than and equal to 50% in B company, then B company would be called as the associate company of A company. So, either more than 20% or less than 50% or equal to 50% of voting rights would allow B company to become associate company of A company. Now, if A company acquires more than 50% of the voting rights in B company, then B company would become the subsidiary company of A company, which would be the holding company. So, the distinction lies in the fact that the exercise of voting powers should be more than 50%. If it is equal to 50%, then C company would again become the associate company of A company and not a subsidiary company. And if A acquires 100% of the voting rights in B company, then B company would be called as the wholly owned subsidiary company of A company. I hope this flowchart makes it clear. That's all from this video. We will continue in the next video with more important definitions given under Section 2 of the Companies Act 2013 and probably finish it off in the next one. Hit us up in the comment section if you have any queries, or write to us at thecaffeinatedcorporatelawyer@gmail.com to give us your feedback. Follow our Instagram page to get some more exciting content, and don't forget to hit the subscribe button if you want to study all the sections of the Companies Act 2013 with us. We will see you guys in the next one. Thanks.